Good afternoon. This is a 20-minute oral argument per side. You may reserve if you can get away with it. And if you are ready, you may proceed.
Chief Justice, and may it please the Court, Sofia Nelson of the State Appellate Defender's Office on behalf of Montez Stovall. I'm joined at council table by my colleague, Adrienne Young. I will attempt to reserve some time for rebuttal, and I welcome the Court's questions at any time. Mr. Stovall's plea and sentencing agreement was induced by a desire to avoid an unconstitutional mandatory sentencing regime. Mr. Stovall gave up his right to an individualized sentencing hearing at which his youth and his greater capacity for change would be considered as mitigating without even being apprised that he had that right. Therefore, his plea violates due process, and he's entitled to a remand for plea withdrawal. It is fundamentally unfair and grossly disproportionate to allow people like Mr. Stovall, who committed crimes when they were children, to spend a lifetime in prison without a process where they can develop the mitigating evidence in their case concerning youth and their greater capacity for change and have that evidence considered. Under his current plea and sentence, Mr. Stovall, like most juvenile parolable lifers, is unlikely to even receive a public hearing, let alone parole. To have a meaningful opportunity at release, as is required by the United States Constitution, and I believe also by Michigan's prohibition against cruel or unusual punishment, that meaningful opportunity must be both realistic and timely realized and tethered to demonstrated maturity and rehabilitation. Mr. Stovall's current sentences do not provide him that meaningful opportunity, and therefore his sentence is cruel or unusual and violates the Eighth Amendment as well, and he's entitled to remand for resentencing. We ask that this court vacate the Court of Appeals opinion and remand with an order for both resentencing and an offer of plea withdrawal.
Counsel, the prosecutor and the Attorney General's parole statistics are more recent than those we got from you all. And assuming they're correct, and I have no reason to believe they're not, I think it's about 20% of parolable lifers are getting reviewed and paroled. Is that meaningful? I mean, how would we quantify what's a meaningful opportunity for release?
Well, I would respond with 2 points there. The actual parole rate, I would argue, is not particularly relevant to what the constitutional mechanism is for safeguarding against disproportionate sentences. So under the parole process, Mr. Stovall has to be interviewed by the parole board again. They never have to speak to him. He's not entitled to an attorney. He's not entitled to court funds for experts to develop mitigating evidence. He's not entitled to an updated pre-sentence investigation report. The parole board is doing a file review without an updated PSIR that would include the mitigating evidence, would include the brain science, stuff that we know about diminished culpability and greater capacity for reform. He doesn't have an attorney, and he has no right to appeal. So absent those things, I don't think there are adequate safeguards in place to protect against disproportionate sentences. So if even just one parolable juvenile lifer was never paroled based on their demonstrated maturity and rehabilitation, that juvenile lifer would serve a disproportionate sentence. And under the current state of Michigan law, we don't have any process to ensure those disproportionate sentences are not carried out. So that is irrespective of what the actual parole rate is. Secondly, I think the fundamental unfairness here is borne out in the statistics, right? The parole process is a political one. It can change at any time. It's unappealable. You don't have counsel, and you can't develop the record, right? However, yes, the parole process rate has increased from less than 1% to 20%. It could go back down tomorrow. It depends on, honestly, the administration that's in charge. The policy directive does not have the force of law. It can also be taken away at any time. And I think the policy directive, frankly, is window dressing, and we see that as a result of Mr. Johnson's amicus. I think he's the longest serving parolable juvenile lifer, and he's been misconduct-free for 35 years. And the parole board's advice to him to improve his chances at release is to avoid situations that would result in a misconduct. So I think regardless of the rate, we need a process by which people's constitutional rights are protected. And we have that in MCL 769.25. those individuals convicted of more serious offenses are entitled to full resentencings where they can develop the mitigating circumstances of youth. A mitigation specialist can be employed to speak to family members, to neighbors, to teachers. They can have a forensic psychological evaluation. They can present witnesses, and all that information ends up in an updated pre-sentence investigation report that then is considered by the parole board. And it's an entirely different process, right? We have 2 tracks for parole in Michigan. There's the parolable lifer track, which requires, they don't have to interview you, but if they do interview you, then they can advance you to a public hearing. But that requires a majority of the board to want to do that. Then when you get to the public hearing stage, that can be vetoed by your sentencing judge, and then you're denied a public hearing. But say the sentencing judge thinks it's okay, and the majority of the board wants you to go to a public hearing, you're at a public hearing without counsel, where the Attorney General gets to essentially cross-examine you. And then, after that, again, without counsel and ability to present any evidence, if the majority of the board wants to parole you, then you get parole. The vast majority of parolable lifers never reach the public hearing stage, versus people convicted of first-degree murder for crimes they committed as children. Over 90% that have been resentenced have been paroled at the earliest release date, because that parole process only requires one member of the board to vote yes, the person that interviews you, and they have to interview you, and they have to read that updated pre-sentence investigation report, and they have to score your parole guidelines. And we have an objective parole system for people who are serving term of year sentences. That objective parole system says, if you've done well in prison, we spit out this algorithm, right? If you score high probability of parole, which Mr. Stovall almost certainly would, we need substantial and compelling reasons to deny you parole. That is a safeguard that prevents people from serving disproportionate sentences. And in the parole
But counsel, just a
context,
quick question though. I mean, the challenge here is that this was 2 murders, correct?
yes,
So you have someone who killed 2 people on 2 separate occasions. It wasn't one act, so you have 2 murders. It's challenging, right? I mean, it's and he's just shy of his 18th birthday. So doesn't that make it a little bit more complicated?
I think we look to what the United States Supreme Court said with regards to Eighth Amendment protections. The
Okay.
heinousness of the offense alone does not justify a death in prison sentence because of juveniles' diminished culpability and greater capacity for change. We have many
Right.
people who were convicted of first-degree murder in this state where they killed multiple people and were days shy of their 18th birthday that are covered under MCL 769.25.
So what do we do with, it seems that the Supreme Court, U.S. Supreme Court in Montgomery seemed to endorse that a parolable life sentence was what would give that hope for release. Is it that they had a fundamentally different understanding of what parole actually is, or maybe parole is in Michigan? Or, I mean, what do we do with, at least under the Eighth Amendment, what the U.S. Supreme Court seems to suggest that the opportunity for parole is sufficient to satisfy the Eighth Amendment?
So I have several responses to that question. One, Michigan has its own constitution that prohibits cruel or unusual punishment, and under Bullock and Loretson, we know that affords broader protections than the Eighth Amendment. And secondly, it said meaningful opportunity at release. And if a hypothetical opportunity to get out was sufficient to solve that Eighth Amendment problem, what we would have seen in Graham is that geriatric release and commutation would have been a sufficient remedy for the constitutional violation there. Mr. Stovall's chances of getting parole off of a parolable life sentence, to me, are not that distinguishable from his chances of getting a commutation. This is not something where there is sufficient safeguards to ensure that the release decision is based on demonstrated maturity and rehabilitation and the mitigating circumstances of youth, especially because Mr. Stovall has no opportunity to present that mitigating evidence to the board. The brain science that is at issue in Miller, Montgomery, and Graham wasn't available to Mr. Stovall in 1992 when he was originally sentenced. It wasn't available to the court. Nobody knew that they needed to consider his youth as mitigating. And that's a right that he gave up, right? We don't even have to get to the cruel and unusual sentence portion. He's brought a claim for plea withdrawal. He gave up a right to an individualized mitigating hearing where I think everyone agrees if he had been charged today with first-degree murder, that's exactly what he would receive, right? He did not know he had that right. He gave it up. His plea was unknowing and involuntary and actually to his detriment. Therefore, it's illusory and he's entitled to plea withdrawal. That's a very narrow path for this court to take to cure the constitutional problem here. Because we're talking, the AG's office said there's 200 people, juveniles serving parolable life right now.
But he could have also received a life sentence without the possibility of parole under
So,
that same scheme, right?
I think there's a lot of things we need to look at here. One, the mitigating evidence in this case is overwhelming. I've handled juvenile life cases across the state, and to see a childhood quite like this, it's quite shocking. He would, I think, almost certainly prevail at a Miller hearing, but let's say he wasn't. People make calculated decisions when they enter into pleas about what rights to give up and what rights not to give up all the time. And when people give up rights they don't know about, they're entitled to plea withdrawal, even if ultimately the end result would put them in a worse position. That's a calculus for the individual to make. And Mr. Stovall entered into an unknowing detrimental plea, and therefore he's entitled to plea withdrawal. Even if he were to go to trial, be convicted of first-degree murder, and receive a life without parole sentence, that's his decision to make about what rights to give up. And he was not appraised of his right to an individualized sentencing hearing at the time he entered that plea. I would also argue the fact that he was offered a plea to second-degree murder is indicative of what the prosecutor's office thought his level of culpability was at the time. There are many juveniles who commit murders where they don't offer plea deals to second-degree murder and pursue that life without parole sentence. That was not pursued in this case. And had
Counsel,
Mr.
my question is, how academic is this? Like, what do you see the end result being on this?
I don't think it's academic at all, Your Honor. I think this is about a relatively small group of people who relied on the current state of the law to their detriment and ended up in a worse position than had they gone to trial and been convicted as charged. We know of the parolable juvenile lifers in the Michigan Department of Corrections. According to Safe and Just Michigan, 58% of them pled. We can assume most of those are pleas from first-degree murder down to second-degree murder. So we're talking about 116 people who have been left behind. Michigan said you cannot sentence people to die in prison for crimes they committed as children unless you go through this process where you're entitled to an attorney, you're entitled to court funds to present expert testimony, you're entitled to confront the witnesses against you, you're entitled to an individualized sentencing hearing. They take multiple days, right? These are complicated, in-depth proceedings. Mr. Stovall and the other, let's say between 100 and 200 people, didn't know they had that right, and they are now serving the functional sentence that they bargained to avoid. So what we have here is a class of more culpable juvenile lifers convicted of first-degree murder being given a very meaningful and overwhelming majority of them ending up with term-of-year sentences that result in their release. And that was a good public policy decision, right? We know the recidivism rate for that group of people is less than 1%. The Supreme Court was correct. Who you are as a child is not who you are destined to be as an adult. There's a greater capacity for reform, and the vast majority of these people are rehabilitated and deserve to come home to their families and have done so successfully. And then you have this small group of people who are watching people more culpable than them go home, get a meaningful second chance, and they're left to languish in prison without an attorney, without any individualized sentencing hearing, and without any due process. That to me is a great injustice.
Aren't your arguments better made to the legislature?
Well, this court is tasked with interpreting this state's constitution and ensuring that nobody's constitutional
But it
rights are
sounds a lot to
violated.
me like your complaint is that the statute that was passed wasn't broad enough or didn't account for this group of people.
With all due respect, Your Honor, the statute was passed in response to the United States Supreme Court's decisions. It wouldn't have come about had the court not passed on what was and wasn't constitutional punishment. And it's this court's job to pass on whether or not Mr. Stovall and those similarly situated's due process rights have been violated, and whether or not they're subject to cruel or unusual punishment. And if they are, to make that announcement, and then the legislature is free to
Isn't
make
your
a
client bound
policy.
by the law, the state of the law at the time he entered his plea agreement? I mean, the Supreme Court's been
that's-
pretty clear on that.
That's an interesting point. So a lot of constitutional rules are not applied retroactively, right? The vast majority. There's a rule against retroactive application. And so I would argue that this ruling that he's entitled to plea withdrawal in this case would not disturb the plea system. We're talking about a very narrow situation where a substantive constitutional rule was applied retroactively pursuant to Teague. So you see recently the United States Supreme Court said non-unanimous juries, that's unconstitutional, violates the Sixth Amendment. Later in Ramos, they said that doesn't apply retroactively. So it was okay to convict you using a non-unanimous jury at the time that was the state of the law. It's not okay going forward. In Montgomery, the United States Supreme Court said it was always unconstitutional to subject juveniles to a mandatory sentencing regime. So actually, we didn't know it, but because of the Teague analysis and what we know about what that means, it was actually unconstitutional at the time that Montez entered his plea. So people weren't aware of it, but the state of the law was in fact that it was unconstitutional to condemn children to die in prison without an individualized sentencing hearing. So we're talking, the vast majority of changes in constitutional law are not going to be applied retroactively and therefore would not entitle someone to plea withdrawal as a result of a change in the law. But this is a special circumstances where in fact that is the appropriate remedy. So I want to talk briefly about the importance of a pre-sentence investigation report. That is the main thing the parole board relies on in making its decisions about parole. Mr. Stovall's pre-sentence investigation report includes nothing about brain science, includes nothing about the diminished culpability of youth. It includes very little about the mitigating circumstances of his childhood. That's the precise type of information the parole board would need to make a decision informed by his greater capacity for reform, the mitigating circumstances of youth, and his demonstrated rehabilitation. That's the type of stuff that needs to get into the record so that the parole board can do its job. The only way to do that is through a resentencing. It would be great if the parole board had a more robust practice. And to return to Justice Cavanaugh's question before I reserve the rest of my time for rebuttal, many state Supreme Courts and federal courts have found parole processes in some states to not offer that meaningful opportunity at release. Parole varies so drastically from state to state that I think that was more of a hypothetical pronouncement by the United States Supreme Court. And when you get down into it, the actual question is there a process by which someone can argue their diminished culpability and their greater capacity for reform, and their release decision be based on that? If so, then yes, they're offered a meaningful opportunity of release. If not, then no, the parole process violates the Eighth Amendment, and we've seen many states hold just that, and numerous ones are cited in my brief.
The current policy directive, though, does in fact instruct the parole board to consider exactly what you're saying needs to be considered.
It does, but it provides no mechanism by which an individual can put that information before the board. They don't have an attorney, they're not entitled to court funds, they're not entitled to appeal, and the board is free to base its decision on the offense alone. The directive says you must consider, but it doesn't provide the kind of safeguards that we see in MCL 76.925, where you can't base your decision without considering those mitigating circumstances, right? You can consider it and say they're irrelevant, we're moving on. And furthermore, that policy directive doesn't have the force of law. It doesn't provide adequate constitutional protection. This court needs to make a ruling to ensure that that happens. And I will see no further questions. Reserve the rest of my time for rebuttal. Thank you.
Thank you.
And may it please the court, good afternoon. John Wojtala, representing the appellee in this matter, the people of the state of Michigan. I know this court is going to hear at least 4 different Miller cases in this particular session alone, and has heard many others, but I do think it's important to understand what exactly Miller said. And what the holding, based upon what Jones versus Mississippi said, was that the holding is very limited. It is that juveniles can't be sentenced to life without chance of parole without the sentencing judge first given some consideration to youth and its attributes. What the Miller court or Montgomery or even Jones, what none of them addressed was whether the Eighth Amendment was changed by Miller as to the voluntariness of a plea. What Miller did not say was that it did not prohibit a juvenile murder, from serving the rest of their life in prison. What Miller didn't address was the Michigan Constitution. And what Miller didn't address was the parole board's policies and procedures. It was very limited in what its holding was. So all the issues that are in this particular case, dealing with this particular defendant, none of those issues were addressed in Miller. And so this concept of Miller, which I don't disagree with, of children are different and you need to be treating them different. This concept, though, sort of blinds people, and I fall victim to this. It blinds people as to the extent of it, where the extent of Miller is actually very limited in its Eighth Amendment application. Now, much of the argument from the defense today really dealt with the procedures of the parole board. That is something that maybe the Court of Appeals below, and what I argued in my case, is that it's really something that if they have a problem with, take it up either with the legislature or take it up in a suit against the parole board. It doesn't go to the validity of this particular sentence. What we're looking at is this is a sentence that violates cruel and unusual punishment. And as my arguments are, it doesn't. With that, I'm open to any questions this court might have.
So I
specific to
understand
it.
the argument about the parole board
Yeah.
and the authority that we may or may not have to do that. But what do you, and I guess the question I asked of the defense, what if the meaningful opportunity for review in practicality, not just sort of in application, I mean, the way, we have guidelines and we have processes. What if it's not, in fact, meaningful review? And so why would that, just because you have a review, if it's not a meaningful review, why is that sufficient to satisfy the Eighth Amendment or our Constitution?
Okay, well, first let me address the one thing that I thought about recently in my mock argument is we are dealing here with a successive motion for relief from judgment. And one thing that did occur to me is that the reason why this was granted under 6.502G was on a retroactive change in the law. The retroactive change in the law being Miller, which dealt with the Eighth Amendment. There is no retroactive change in the law dealing with the Michigan Constitution. So I think the Michigan Constitution issues are things that are, you don't get past 502G on the Michigan Constitution cases because there is no retroactive Michigan Constitution law to apply. But going to that is, I think you have to separate the question of the validity of the sentence, which is what a criminal appeal deals with, and the fairness or any constitutional violation, what the parole board is doing, whether they're giving meaningful consideration to the defendant, whether the policies that they have in effect are unconstitutional, unlawful. That's a separate question from the validity of this particular sentence. At the time that the judge gave the sentence, life was a good sentence. It still is a good sentence to give for a murder too. It was proportionate, I think, to the crimes that occurred here. It's not something that violates cruel, unusual, or cruel and unusual punishment. But I think whether or not the parole board's policies are sufficient to meet meaningful consideration, that's a separate question from the question that's before
But
the
can't
court.
we, say that the parole board's policy is to have janitors review whether or not somebody gets parole. We can just ignore that and say, well, he's got an opportunity for parole, therefore it meets a constitutional standard. Or can we look at what, in fact, is the process available?
My argument to that is is something probably this court can review, just not in the context of the case that we have here, the criminal appeal of the validity of the sentence. Because we're dealing not with what the sentence whether it was cruel and unusual for the actual sentence that was given, which was life. The question that you're asking upon is the sufficiency of the parole board's policies and procedures in upholding the Eighth Amendment.
I think what we're asking is the constitutionality of his sentence in light of the reality of his opportunity for meaningful, for release?
Okay, so I guess the first thing to say is that, as what this court has already indicated during this argument, is that the U.S. Supreme Court has already addressed, and what I think this is actually your question, the U.S. Supreme Court has already addressed the fact that this meets, at least not held, but at least strongly indicated that a parolable life sentence was sufficient to meet the requirements of a meaningful consideration. That in itself.
Under the Eighth Amendment.
Under the Eighth Amendment. So again, and I hate to keep going back to this, is that you look at what the sentence is and determine whether that's cruel and unusual punishment. And that's, for me, that is a separate question to whether or not the policies in the parole board.
Can I follow up then on that?
Yeah.
Yeah, no, I think you've answered my question. I appreciate it.
So the legislature in the Miller Fix statute gave people who commit first-degree murder this opportunity to either have a term of year sentence or this hearing with close consideration of the Miller factors, which then can follow them throughout throughout whatever happens after that. But it left somebody who commits a second-degree murder who could be sentenced to parolable life with neither of those opportunities, and with this opportunity that they can get reviewed for parole, which doesn't even mean review by the whole parole board. And so it seems to me the legislature thought that the fix to the first-degree murder life without parole sentence, it wouldn't be good enough to do life with parole. They thought the fix had to be something better than that. And so now people who are convicted of second-degree murder have less opportunity than I feel like the Miller Fix statute made the sentence for second-degree murder for juveniles only cruel and unusual, or unusual, but maybe one or the other. What can you respond to that? I know this isn't exactly what maybe you showed up to talk about, but I do feel like the Miller Fix has made this class of defendants facing a sentence that's could be cruel or could be unusual.
Okay, so how I view it is how Jones versus Mississippi found this, is that what is important is that the judge has some discretion to consider youth and its attributes in the sentencing of the defendant, okay? And so that doesn't exist with the murder one. That didn't exist with the murder one prior to Montgomery and the statutory fix, is that it was a mandatory sentence. There was no discretion that was given to the judge. The judge had to give this sentence. So the statutory fix addressed that. Now it gave discretion to the sentencing judges. That even if the prosecution said, no, you should get life, this still went before a judge, and the judge had to hear evidence and go through the entire Miller hearing on it and make a discretionary decision as to what was the most appropriate sentence. With murder two, I can't think of a situation where it's not discretionary to the judge at some point. Either we're going through a trial, we're going to go through the whole process of scoring the guidelines and coming up with a guideline range, and the judge determines, okay, well, where in that guideline range, or up to life, do we give this defendant, or we have a situation like we have here where there's a plea agreement or a sentence agreement, where the judge then has also the discretion to say, you know what, I don't like that sentence agreement, I'm not going to go forward with the sentence agreement. There's always an aspect of discretion, which is what Jones versus Mississippi spoke about as to what Miller actually means. There's always that aspect of discretion with the murder two cases.
I think I understand. So the answer is that there's just not the same problem because the judge in a second-degree murder conviction sentencing has an opportunity to consider youth. Is that fair? Mm-hmm. But still, that the person in that situation doesn't get the benefits that somebody who's convicted of a worse offense gets, right? I mean, they don't get the benefit of either a term of year sentence or this full-blown hearing, right? These procedural protections that it feels like you're better off committing a worse crime. It feels like the Miller fix put this class of defendants in a difficult position. Whether it's a cruel one or an unusual one, I'm interested in your views, but
If I could follow up on that, is it the Miller fix that created that, or is it the way that the parole board functions? Because back, whatever, 30 years ago, I can't remember exactly when, it was that the judges said it because they knew that it was a parolable life sentence, you'd be out, eligible in 10, and a lot of people got out in 10.
Mm-hmm.
So is it the process that the parole board has used that has created this problem, or is it the fix that the Michigan legislature did in response to Miller?
Well, first I'll start off with is the idea of a problem. I don't know if it's actually a problem anymore, as illustrated by the AGs and the statistics put in there, is that this idea of, which is court put in its order granting oral argument in this, that there is this existing policy of life means life by the parole board, which I'm assuming is what the problem that you're addressing, is that these people who have been sentenced to life imprisonment are going to be serving this term, that they're never going to see the light of day and leave prison. That doesn't actually exist. That there's statistics to show that a good majority of, not majority, but a good many of them every particular year are granted parole, or granted release. So I'm not going to concede the fact that there is a problem. But what my argument, I guess, is that the Eighth Amendment in Miller, what they spoke about in the Eighth Amendment, was a specific issue with the sentencing of juveniles. And the fix was to address that particular issue. And that particular issue was that there was no discretion given. It was a mandatory sentence. So the fix that was created was to address the particular issue of these mandatory sentences that Miller highlighted, and Montgomery highlighted. That just does not exist in the murder two context. So that's why I don't think that there is a problem.
Well, maybe not right now.
Yeah.
I mean, if the parole board, if their policy was what it was 30 years ago, where it was a parolable life meant that you were eligible for parole at 10 years and likely were to get out at 10 to 15, I don't think we would be here today, because that term would be less than the mandatory term of years under the Miller statute,
Yeah.
right? So we probably wouldn't be talking about that. Then there was a period of time where life meant life, and we were at 1% of parolable lifers actually getting parole. And now we're shifting, but there's nothing to say that it wouldn't shift back to one of those other two. So I mean, I think when we're talking about a problem, it's the problem of that process, and that's what we're struggling with.
And that's where, and maybe I'm the one that's struggling, probably. And it sort of goes back to Justice Cavanaugh's questions too, is that I view this as so reviewing this on a continuum of what the parole board has been doing. So they had this period of time which you've indicated that you get eligibility after 10 years, after, a certain, you would expect to be paroled after 15, 20 years. We had that period, you had another period where it was much lower, and you have the period now where 20% of lifers are given that. So we have this continuum, but that's based on the policies of the parole board. What has made consistent has been the ability to give life, whether this is a valid sentence that can be given. And does that constitute cruel and unusual? And that's what we're here for in this criminal case. Is this a valid sentence? Is this in itself, is life a cruel and unusual punishment for juvenile defendants? That's remained consistent, and my argument, of course, is that it is not, because there is a sentence, there is a discretionary aspect of it which solves the Miller problem, I believe. This is a sentence that has been in the books for years and years and years. But that's a separate question from the policies of the parole board. Now, if that is an actual issue, if life meant life, and lifers were not getting out of prison, and this has come up before, that is an issue to be taken up with the parole board, not with a challenge to the validity of the sentence.
And then just one more question. You talked about the retroactivity of Miller, and that there's not a retroactive, that issue isn't here because it wasn't a Michigan constitutional question. So this was not the right case to bring that in. So what do you view as the right case? Something post Miller where a youth is charged and takes a plea, or is convicted of second degree and then isn't, and gets a parolable life sentence, and then we have to wait for them to first be eligible? Like, is that, I'm just trying to figure out what that right case is and how long that takes.
Well, it certainly isn't this case as well. It's because we're dealing with the addition of the 6.502G. If this was a regular motion for relief from judgment, that might be an appropriate sentence, and I know that's sort of the issue that you're going to be dealing with this afternoon, where you have two cases that are going to be argued to you. One is a motion for relief from judgment case, and one's a direct appeal, and what difference that makes. I think it does make a big difference when we have a successive appeal, so that's why that's not the situation here. But if you do have a case where it does become an issue on direct appeal, or it does become an issue on the first motion for relief from judgment, then I think that may be a more appropriate case.
Okay, thank you.
I'm struggling a little bit with the maturity and rehabilitation. So Miller reiterated Graham, the state's not required to guarantee eventual freedom, but must provide some meaningful opportunity to obtain release based upon a demonstrated maturity and rehabilitation. And then in Montgomery, the court said, you don't have to do a resentencing. It's sufficient if you permit juvenile homicide offenders to be considered for parole. So taken together, what does that mean? Is it sufficient that parole eligibility satisfies Miller and Montgomery, or is it parole eligibility where the parole board must consider maturity and rehabilitation as in the process of determining whether parole is appropriate?
Yeah. And I think in a certain aspect that Miller and Montgomery, that's the Graham analysis, and in Miller, Graham was only mentioned, really, this aspect of Graham was only mentioned once and basically in passing. But because Miller and Montgomery both deal with the idea of a juvenile serving life without parole, like serving till death in prison. Graham seems a little misplaced in that, because in Miller they say it is proper. I mean, it is still a good sentence. You do have to follow this sentencing scheme, but it is. We're not going to say it's against it's cruel and unusual punishment to have a juvenile serve life without parole. So to have that aspect of Graham, I think, is a bit of a dicta in both Miller and Montgomery. But to the extent that it does apply here, even the Michigan or U.S. Supreme Court has struggled with what is a meaningful consideration of parole for parole release. But I do think that their language in Miller and in Montgomery in indicating that a parolable life, the chance to have parole, the chance to go before the parole board, whether or not the parole board grants it or not, that opportunity is a meaningful opportunity, that you do have those mechanisms available to you to go before the parole board and make your case, is what a meaningful consideration is.
Thank you.
With that,
Thank you, Counsel.
thank you very much.
Thank you. You managed to reserve 1 minute and 38 seconds.
Okay, 2 quick points. First, that this isn't the proper vehicle. I would strongly disagree. So this goes back to Justice Clement's point in Manning, based on is a procedural threshold question, and then you move to the merits. So Mr. Stovall's claim is based on Miller, a retroactive change in law. He couldn't have brought it sooner. And then you move to the merits analysis, which can include this court's interpretation of Michigan's Constitution. This is not a problem that's likely to present itself in the future, because no one would bargain for a life with parole sentence if they had the opportunity at a Miller hearing, right? So this is something that you're going to have to address through 6500, because it's not a problem that's likely to present itself going forward. This is about a left-behind group of people. Mr. Stovall's is precisely the case that this court should address this issue. The question of whether or not the proper way for Mr. Stovall to attack this is by suing the parole board. There are many constitutional problems where there are multiple avenues for someone to pursue relief from that. The constitutional question of whether or not Mr. Stovall's plea violates due process is properly before this court. It is Mr. Stovall's sentence that then triggers the parole board's practices. The relief we are seeking, resentencing and plea withdrawal, is not relief the parole board can offer. Mr. Stovall could sue the parole board all day long. They can't resentence him, and they can't offer him plea withdrawal. Therefore, civil action against the parole board, while may achieve something else, doesn't actually address the constitutional questions that Mr. Stovall has brought before this court, which is that his sentence is unconstitutional, it's cruel or unusual, and that his plea violates due process.
Thank you. The case will be submitted. We will take a short break and be back at 1:30.